Why do some lawyers win trust before the first witness even speaks? Because opening statement is not a warm-up. It is the first real chance to shape how jurors hear everything that follows. According to Pace Law School's Hobb Advocacy blog, a strong opening sets tone, introduces the people, and gives jurors a clear path through the facts and legal stakes. That article frames one core lesson. Opening is not closing. The job is not to argue. The job is to preview what the evidence will show. The American Bar Association makes the same point. An opening should forecast the evidence, help jurors organize what they will hear, and avoid slipping into argument. That matters because first impressions stick. Think of opening statement like the spine of a book. If the structure is clear early, every later detail has somewhere to go. The article draws a sharp line between theme and theory. Theme is the memorable idea. Theory is the full explanation of what happened and why the law supports your side. The ABA says an effective opening often turns on a simple phrase or sentence that jurors can carry into deliberations. Simple beats crowded. Clear beats clever. And structure matters more than many new lawyers realize. The ABA advises advocates to tell the story in plain language, with a beginning, middle, and end. That way, jurors can fit each witness and exhibit into a coherent sequence, instead of hearing facts as scattered pieces with no frame around them. That becomes even more important in complex cases. When evidence gets technical or dense, jurors benefit from an organizing framework early. They are being asked to absorb law, facts, credibility judgments, and burden of proof all at once. A clear opening helps them know where to place each part. Another lesson is delivery. The article stresses eye contact, conviction, and purposeful movement, not performance for its own sake. Presence that helps jurors trust the messenger. That advice lines up with recent ABA guidance on rhythm and silence. Opening statement is the advocate's first and best chance to frame the narrative. A pause after the core theme gives the idea room to land, instead of getting buried under the next sentence. The article also points toward a deeper reality. Jurors are not just collecting facts, they are building mental expectations. ABA trial guidance notes that opening statement helps jurors know what to expect, which means your opening is teaching them how to listen before the testimony ever begins. The article also offers a useful warning through a mock trial story. New advocates often cling to the script. They chase perfect wording and lose the larger story. That is a practical training point for any trial lawyer. Write the opening, then practice until you can speak it, not read it, while staying accurate to the evidence. The ABA's Young Lawyers Guidance adds a blunt reason to rehearse out loud. Something that looks strong on paper can sound stiff, rushed, or argumentative when spoken. Hearing the words exposes what the page can hide. Credibility also grows when you address weaknesses without panic. The article emphasizes honesty and authenticity. Jurors can sense when a lawyer is hiding from a hard fact. That is not just style, it is discipline. The ABA's jury trial standards say counsel should not allude to evidence in opening unless there is a good faith basis to believe it will be offered and admitted. In plain English, do not promise a dramatic fact unless you are prepared to deliver it through admissible proof. If you overpromise early, trust gets harder to recover. There is also a strategic reason to be candid about limits in the proof. Openings are a chance to explain what evidence will and will not exist. If a juror expects a perfect forensic trail and your case will rely on testimony, documents, or circumstantial proof, opening is where you explain that before absence turns into doubt. So what should viewers practice? Build a one-sentence theme. Build a clean theory. Then deliver the first minute out loud with calm pace, eye contact, and deliberate pauses. This is not legal advice for any specific case. It is trial skill training. The goal is to help advocates become clearer, steadier, and more persuasive in court. Next time you prep an opening, practice the first 60 seconds until it sounds natural and grounded. Practice this skill with AI-powered courtroom drills at trialtutor.com. If you want more breakdowns like this, like, subscribe, and share. Strong trials often begin with strong openings, and strong openings begin with disciplined practice.